Good afternoon, class. Today's lecture will be Title 5 of the Revised Corporation Code of the Philippines. We will be talking about bylaws. For this topic, remember our source material is the book Partnerships and Private Corporations by De Leon and De Leon as is applicable to the revised code, and also the book Revised Corporation Code of the Philippines, a short introduction by Aquino and Aquino. So anyway, let's begin with the power to adopt bylaws. Remember, the power to adopt bylaws is an express power and also an inherent power. Remember, the powers cut across one another. So anyway, bylaws definition, rules of action which are adopted by a corporation for its internal government and for the government of its stockholders or members, and also those who have the direction, management, and control of the affairs of the corporation, meaning yung directors, trustees, and also officers. Also, yung bylaws can provide for rules regarding routine matters. So anyway, corporate power to adopt bylaws is expressly provided for under sections 35 and also 45. Remember that it is also an inherent power of the corporation. And with respect to the adoption of bylaws, even holders of non-voting shares or non-voting members are allowed to vote. Now anyway, the functions of bylaws, very simple, based simply on the definition. You will get also what the functions of bylaws are. So obviously, it will define rights and duties of officers, directors, trustees, and of stockholders or members towards the corporations and also amongst themselves. So it will also regulate the transaction of business noong corporation. So what else do you have to remember? The reason why we adopt bylaws. So the first reason why corporation must adopt bylaws is because it is practical and also there is a legal necessity to adopt bylaws. So remember, a corporation will begin its existence in at the time that the certificate of incorporation is issued to it. But remember, even if there is a certificate of incorporation, meron ng existence, yes, but the corporation is not prepared to do business as of yet. Now, paano niya ma-accomplish yung kanyang business or yung kanyang purpose? It must have executive officers. Okay, kailangan meron siyang magmamanage ng kanyang affairs, and also it has to have rules to govern yung management ng kanyang business. So, paano nagagawin ng corporation yan? It must adopt yung bylaws. Because remember, again, as I've said a while ago, the bylaws will define the rights and duties of the corporators in a corporation. So, upon the issuance of a certificate of incorporation, yes, the corporation is in existence, but it is not yet organized. So, kailangan ng bylaws for the government of the corporation and to define the rights and duties of the corporators. Yan. What else? Number 2, in case of a corporation sole. So remember, in case of a corporation sole, it is allowed not to adopt bylaws. Bakit? Kasi ang mga provisions ng bylaws is already contained doon sa kanyang rules, regulations, and discipline pertaining to the religious denomination. So usually, talagang hindi na nila kailangang mag-adapt ng bylaws. Anyway, if there are provisions which are not contained in the rules, regulation, and discipline of the religious denomination, they can expressly include it in the articles of incorporation para lang ma-regulate yung kanilang affairs. So please take note that in case of a corporation sole, hindi nila kailangan na mag-adapt ng bylaws. So it does not need to comply with Section 46 of the Revised Corporation Code of the Philippines. What else? In case of one-person corporations, so obviously in case of a one-person corporation, it is not required to file bylaws in accordance with Section 119. This is a new provision again, and also, but remember, it is required to file the articles of incorporation as defined in sections 13 and 14. Now, the next question is, when and what is the procedure for the adoption of bylaws? So, time and procedure as provided for in section 45. Obviously, bylaws can be adopted before incorporation, and yung bylaws nyo will be submitted together with the articles. So, bylaws may be adopted and filed prior to incorporation. So, remember that the bylaws, if you want to adopt it before incorporation, must be approved and signed by all the incorporators and submitted to the SEC together with the articles of incorporation. However, class, you can also adopt bylaws after incorporation of the corporation. So, after the receipt of the certificate of incorporation, pwedeng mag-adopt ng bylaws yung corporation, provided it is not inconsistent with the revised corporation code. Before, in the old law, remember, a corporation has 30 days to adopt bylaws after incorporation, after the issuance of the certificate. Pero tinanggal nila yung provision na yon. And now, it is not clear until what time or until what period a corporation can file yung kanilang bylaws if it is adopted after incorporation. So anyway, to adopt bylaws after incorporation, affirmative vote of the stockholders representing majority of the outstanding capital stock, or majority OCS, or majority of members in case of non-stock corporations. Also, take note that this time, the bylaws, instead of the incorporators signing the bylaws, it will be signed now by the stockholders or members voting for them, and it will be kept in the principal office of the corporation and subject to inspection, reasonable hours during business days. Also, copy thereof, certified by majority of the directors or trustees, countersigned by the secretary of the corporation, shall be filed with the SEC, and that will be attached to the original articles of incorporation. So anyway, in both cases, yung bylaws will be effective only upon the issuance of the SEC of a certification that they are not inconsistent with the revised Corporation Code of the Philippines. Also remember that with respect to corporations governed by special laws, the SEC will not accept yung bylaws or any amendment thereto if it is not accompanied by favorable recommendation from the appropriate government agency. The favorable recommendation obviously will state that the bylaws, or if in case it is an amendment, or any amendment thereto, are in accordance with law. So now, if there is no provision there's no period within which you have to file the bylaws in case it is adopted after incorporation, what is now the effect if the bylaws are not filed? So anyway, that is the rule for the bylaws of special corporations. Effect of failure to file bylaws. So remember, class, non-filing of bylaws will not result into the automatic dissolution of a corporation. So this consequence is not provided for in the revised Corporation Code. However, pursuant to the SEC Reorganization Act, or PD 902-A, failure to file a code of bylaws with the SEC shall render the corporation liable to the revocation of its registration, suspension, or imposition of administrative fine. But remember, class, there must be due process before these penalties are imposed. Suspension or revocation, imposition of administrative fine. Bago i-impose yan, there must be due process, meaning there must be a hearing and there must be really a finding na wala talagang bylaws na i-final. So anyway, failure may be met with imposition of penalties only, but not automatically revocation of the registration of the corporation. Now, what is the status of a corporation that did not file its bylaws? So remember, in case a corporation does not file its bylaws, the status of that corporation, assuming that it exercised the rights of a corporation or the powers of a corporation, remember, it is a de facto corporation because a certificate of incorporation was issued to it, remember, and they exercised in good faith yung powers of a corporation. Now, the failure to submit bylaws, in case of failure to submit bylaws, a corporation may be considered a de facto corporation. It will not ipso facto lose its powers as such a de facto corporation. Anyway, if you remember when we discussed de facto corporations in Title 1, ang sabi natin de facto corporations are corporations recognized at least with respect to third persons and also other corporations. Hindi lang considered na corporation ang isang de facto corporation when it comes to the state. Only the state can question the franchise of de facto corporation by a direct proceeding, again known as co-warrant of filed by the Solicitor General. So anyway, the elements of valid bylaws, not contrary to 1 and 2, not contrary to Lamog PP, and not inconsistent with the Revised Corporation Code of the Philippines. So again, Lamog PP, law, morals, good customs, public order, and public policy. So what else? They must not impair obligations of contracts or impair vested rights, meaning if there are rights already recognized, contractual rights, and also vested rights, hindi pwedeng gumawa ka ng bylaw which will impair yung rights already existing because of contract and yung mga vested rights. What else? General and uniform in application and not directed against particular individuals and not discriminatory. It should, again, apply to all. Ngayon, kung hindi nag-a-apply to all, obviously, the reason for not applying to all is because there are germane differences between yung mga persons who are involved. What else? They must be consistent with the Articles of Incorporation as well. And lastly, they must be reasonable. Common sense na lang siguro to. Matanda na kayo, kaya nyo na yan. What else? Also, please take note of the operation and binding effect of bylaws. So remember, the operation and binding effect of bylaws, they have the same effect as the charter of the corporation. So again, the charter of the corporation consists of the Revised Corporation Code of the Philippines, or the General Enabling Law, and also the Articles of Incorporation. So insofar as the corporation and the persons within the corporation are concerned, the bylaws has the same force and effect. So they are written into the fundamental law of the corporation. Also remember that the corporation and its directors, trustees, and officers are bound by the bylaws and must comply with them. How about in case of employees? Must they comply with the bylaws? Yes, if they are aware of the provisions of the bylaws. Now, if they are not aware of the actual provisions of the bylaws, they are not bound, obviously. And as to third persons, remember, general weight of authority is that they are not bound by the bylaws unless they have knowledge of the provisions of the bylaws, either constructively or actually. Now, how about the contents of bylaws as found under Section 46 of the Revised Corporation Code? So some of them will be discussed right now, but some of them we will discuss later on as we go to the specific titles which cover them. So anyway, time, place, manner of calling and conducting regular or special meetings of directors, trustees, and stockholders or members, and the mode of notification for said meetings. So this is more particularly discussed in Title 6 of the Revised Code. Doon ko na lamang i-discuss ito. Also in terms of quorum, discussed under Title 6. What else? modes of attending meetings and casting votes of stockholders or members and directors or trustees, also discussed in Title 6. But with respect to election of directors or trustees by the stockholders or members, we have already discussed this in Title 3. Remember, to elect directors or trustees, ang mag-elect sa kanila is yung stockholders or members, as the case may be. They can employ straight voting and also cumulative voting. So remember, in straight voting, number of shares owned times the number of directors to be elected. That is the number of votes na meron ng isang stockholder. In case of a non-stock corporation, each member is entitled to 1 vote per trustee to be elected. So if there are 5 trustees to be elected, yung member is allowed 5 votes. So that is what you have to remember about election of directors or trustees. In case of proxies, we will discuss this also when we go to Title 6. What else? Qualifications, duties, and responsibilities of directors or trustees. So this must be fixed in the bylaws. So yung qualifications, duties, and responsibilities must be fixed in the bylaws. But remember, even if the qualifications, duties, and responsibilities are fixed in the bylaws, remember, they must not dispense with the minimum requirement provided by law. Meaning, kung ano yung minimum. Kung sabi ng law, ang stockholder must own at least 1 share of stock. Hindi pwedeng sabihin sa bylaws na a director cannot own, a director is allowed not to own a share of stock. So, if in the law, sabi ng law, the director must own at least 1 share of stock, hindi pwedeng lalagay mo sa bylaws mo na pwedeng wala ng share of stock ang isang director. Also, you cannot provide in the bylaws that trustees are not allowed to be members of the non-stock corporation. Bawal yon. Because remember, again, the minimum set by law is that in case of trustees, they must be members of the non-stock corporation. Also, qualifications, duties, responsibilities, kung it can be provided for in the bylaws. The bylaws can also provide for disqualifications. So, bawal ang isang director bawal maging director ang isang tao who is also a director in another corporation. So, or a director who is engaged in who is engaged in a business which competes with the corporation. The bylaws can provide for such kinds of disqualification. So remember, pwedeng ilagay ang qualification and obviously pwede ring ilagay ang disqualifications, responsibilities, and also duties of directors or trustees. What else? Guidelines for setting compensation of directors or trustees. We already discussed compensation in Title 3 actually. So, remember class, as a rule, stockholders, majority stockholders, majority OCS, and also majority of the members may grant directors or trustees with compensation if the same is not fixed in the bylaws. So remember, majority OCS, majority members, they must approve this at a regular or special meeting. But again, directors and trustees cannot participate in the determination of their own compensation according to Section 29. And please take note also again that directors or trustees are entitled to receive per diems. So even if it is not provided for in the bylaws or there is no stockholders or members resolution providing for per diems, it is allowed to be given to directors or trustees. Again, directors or trustees shall not participate in the determination of their own per diems. What else? In case of stockholders, can they receive compensation? Of course not, class. So they are not entitled to receive compensation or even per diems if they attend meetings. Because when they attend meeting class, they exercise personal rights in the corporation. So bylaws, even the bylaws cannot provide that direct stockholders or members will receive per diems or compensation, especially if they are not directors or trustees, officers, and employees. Because if a stockholder or a member is also a director or a trustee or an officer, an employee, the rules are different now. What else? Election and term of office of directors or trustees. So actually, class, if you will take a look at this provision, the bylaws cannot provide for the manner of election because that's already provided by law. Sinabi na ng law how the directors or trustees will be elected, which I have already discussed just a few minutes ago. And also remember that the bylaws cannot provide for a term of office because again, that's already provided for by law under Title 3. Remember, directors to serve 1 year, trustees not more than 3 years until their successors are elected and qualified. Remember again the holdover principle when you talk about term of office. Kailangan idagdag nyo yung holdover until their successors are elected and qualified. Now here, ang pwede lang talagang i-provide ng bylaws is yung time of the holding of the annual election and the manner of giving notice by the corporation. Giving notice to the stockholders or the members by the corporation. So, yung election, technically, and term of office, hindi na nila pwedeng galawin yan. What they can do only is to provide for the time of annual election and the manner of giving notice of yung election of directors or trustees. So, that is actually misleading. Anyway, alam nyo naman na yung correction. Imposition of penalties or sanctions. So, again, a corporation, if it makes bylaws, obviously, it must enforce the bylaws that it makes. Now, what if there are violations dun sa bylaws na ginawa ng isang corporation? Obviously, the corporation can also impose, they have the power to enforce pecuniary penalties and corporate disabilities which are proportionate to the violation. So, ang kailangan nyo lang namang tandaan dito is that even if they can enforce penalties or sanctions, ano bang example ng penalties or sanctions na pwedeng i-impose? Suspension, etc. Expulsion of members in case of non-stock corporation because of misconduct, non-payment of dues, etc. Ang kailangan nyo lang naman tandaan yan, pwedeng gawin ng corporation yan, yes. But in case of stock corporations, especially of stock corporations, the bylaws cannot enforce a forfeiture of property or stock of the defaulting stockholder. So, hindi pwedeng bigla na lang kukunin ng corporation yung shares of stock ng isang stockholder due to a violation of the bylaws. Yan. So anyway, if there are violations of the bylaws and there are no penalties or sanctions imposed doon sa provisions, wala siyang provisions which defines yung mga penalties or sanctions, there is obviously an actionable wrong. So yung actionable wrong na yan, pwedeng magpunta sa court ang corporation to address yung mga actionable wrongs committed by the stockholders or the members. Usually naman, ang mga violations will consist halimbawa, yung mga officers, ang usually violations nila is failure nila to perform the duties imposed in the bylaws. So, the usual remedy there is to go to court and file an action for mandamus. So, anyway, remember that. What else? Issuance of certificates of stock. So, remember, certificates of stock or stock certificate is, again, internal matter which is left to the discretion of the corporation. But, again, ang tandaan nyo na naman dito, we will discuss this more when we go to Title 7. Yung authority granted to a corporation is strictly to regulate the transfer of the shares. paanong regulate? It will authorize the adoption of rules and regulations and formalities and procedure to be followed to effect transfer. But it cannot restrict the transfer of shares, subject to exceptions when it comes to yung closed corporation. What else? So, sa madaling sabi, in number 9, pwede niyang i-devise or i-define kung paano ang pagbebenta, procedure sa pagbebenta ng shares, paano ang procedure sa paglipat sa pangalan ng buyer yung shares. But it cannot restrict or hindi niya pwedeng bawalan yung transfer ng shares. What else? In case of number 10, the bylaws can also provide for an arbitration agreement. So, an arbitration agreement may be provided not only in the bylaws but also in the articles of incorporation. So, yung arbitration agreement, remember, if there are disputes between the corporation and its stockholders or members, or amongst the stockholders themselves or the members themselves, or yung tinatawag nating mga intra-corporate disputes. So, these matters can be referred to arbitration. So, pwede itong i-refer sa isang arbiter, and the arbiter will decide on the dispute. The decision of the arbiter is obviously binding on the corporation and the stockholder. In case ang involved sa dispute is stockholder and stockholder, also binding. However, a dispute is non-arbitrable when it involves criminal offenses and there are third parties involved, in which case hindi na siya intra-corporate dispute. It does not anymore arise from intra-corporate relationships. What else? Please take note also of that the enumeration in Section 46 is merely directory. If the corporation does not make a provision for all of the matters already which I have mentioned, remember, class, that it will not affect the validity of the bylaws. What else? Section 47 talks about the amendment and repeal of bylaws. So, anyway, what you have to remember about the amendment or repeal of bylaws is that it is the stockholders who have the power to amend and repeal bylaws. Siyempre, pagka nag-amend ka, you make necessary changes. If you repeal the bylaws, wala na talagang bylaws. Now, if you repeal the bylaws, you have to adopt new bylaws. So, anyway, obviously, if you have the power to make bylaws, you have the power to amend it, and also you have the power to repeal them, and also you have the power to enact new bylaws. Yan. Subject to the limitations, again, provided by law. So, the stockholders, as I've said a while ago, like 10 seconds before, the power is exercised by stockholders or members directly. But, kung tinatamad sila, they may delegate the same power to the board of directors or trustees. Now, the requirements for the amendment and repeal of bylaws, and in case it is repealed, obviously you need to adopt new bylaws. These are the requirements: majority BOD or BOT. What else? Majority OCS or majority of members in case of non-stock. What else? In all cases, the power can be exercised only at a regular or special meeting, duly called for the purpose, and also with proper notice. And even holders of non-voting shares or non-voting members, as the case may be, are entitled to vote on the matter. So remember, in the adoption of bylaws, they can vote non-voting shares. In the amendment and repeal and also the adoption of new bylaws, obviously, they can also vote. What about in terms of the delegation of the power to amend and repeal bylaws and to adopt new bylaws? So remember, the stockholders or the members can so delegate this power to the board of directors or trustees, as the case may be. Now, anong kailangan to delegate this power? So remember, 2/3 votes of the outstanding capital stock or 2/3 of the members in case of non-stock corporations can delegate yung to the board of directors the power to amend or repeal or adopt new bylaws. So 2/3 OCS, 2/3 members, and also there must be a stockholders or members resolution which will authorize the delegation of power to amend or repeal and adopt new bylaws, and this resolution is certified under oath by the corporate secretary and majority of the directors or trustees, and this will be filed together with the amended or new bylaws in case there is a total repeal of the old bylaws. So it will be filed together with the amended or new bylaws. So remember also that this power, the SEC suggests that this power, is the delegation of the power to the directors or trustees should not be embodied as a provision in the bylaws itself, because it can happen that the authority has already been revoked by the stockholders or members, but kailangan pa ng amendment ng bylaws para lang mag-reflect yung revocation ng power. So anyway, we are talking about revocation. So obviously, if this is a delegated power, it can also be revoked. Now, in case of revocation, remember, to revoke the delegated power, the law will require only majority OCS and majority of the members. So again, to delegate 2/3, to revoke the delegated power, majority. So it is easier, remember, to revoke than to delegate the power. Also remember, class, that revocation shall be valid notwithstanding that no previous notice was given to the stockholders or members of the intention to propose such revocation. So in a meeting, there is no need to previously notify the stockholders or the members that there will be a proposal to revoke yung delegated authority given to such directors or trustees to so amend or repeal or adopt new bylaws. So what else? Please take note also of the filing and effectivity of amended or new bylaws. So remember, as in the case of the original bylaws, amended or new bylaws will be effective only upon the issuance of the SEC of the certification that the same are not inconsistent with the revised Corporation Code of the Philippines. So remember, there is no immediate implementation of the amended or new bylaws hanggat walang certification or approval from the SEC. Also, application of amended or new bylaws will be prospective, not retroactive. So it looks to the future. Yun nga ang bylaws, remember. And SEC will not accept for filing bylaws or any amendment thereto of any corporation vested with public interest or other special corporations if not accompanied by the certification from the appropriate government agency to the effect that the bylaws, new bylaws, or any amendment thereto are made in accordance with law. So in cases of corporations vested with public interest and also special corporations, kailangang i-approve yung kanilang bylaws both by the appropriate government agency and also the SEC. So anyway, that's it for Title 5 bylaws. Please stand by for Title 6 meetings. Thank you, class, and have a good day.